May it please the court. This case is about Louisiana's effort to regulate and significantly change a federal spending power.
You might have to speak up a little, and everyone's divided time, which is appropriate. Have you divided topics, or will there be a little bit of overlap?
I think we have divided topics, and perhaps there will be a little bit of overlap.
What's the rough roadmap, if you don't mind?
I will cover Astra, and then the Novartis case in the DC Circuit, along with the Sanofi case, and I may, time permitting, get to enforcement issues.
So you're mostly talking about preemption?
I am mostly talking about preemption. Almost exclusively, in fact, Your Honor.
Thank you.
To receive reimbursement from Medicare and Medicaid, drug manufacturers must first sign a federal contract under the 340B program and agree to offer certain drugs to 15 types of healthcare providers.
We know the background. Your time's precious. I ask a lot of questions. What's the rough circuit landscape? Because this is being litigated against state laws all around the country. We know the 8th Circuit. The 4th Circuit's hearing a case tomorrow. What I'm particularly interested in, our court has these issues pending in front of it or not? 3
cases, Your Honor, all appeals from denials of preliminary injunction argued in February and April.
Okay.
In this circuit.
And at the moment, though, you haven't asked us to hold in abeyance our decision for that. Is that because the arguments here are meaningfully different, or they've been presented to those panels?
I think they're roughly the same, Your Honor. It's just the procedural posture that's different. This is the summary judgment motion. Those are preliminary injunction motions. We are awaiting decisions on those and are quite interested in the outcome.
And obviously that could constrain our flexibility as well.
It will address the likelihood of success on the merits on preemption and probably a couple other issues.
Am I right that Sanofi is a little bit two-sided? You may have gotten out of the pan into the fire. In other words, the analysis that the 3rd Circuit conducted would suggest there's really nothing textually in 340B that speaks to delivery and distribution.
I think, Your Honor, one of the principal points I'd like to cover here is that the DC Circuit addressed essentially the same issues as in Sanofi. It went further and addressed another issue in 2024, but the district court didn't cite or rely upon that case at all. And so if I might start with that case, it really is central to some of the issues here. First, it construes Section A1 of the federal statute. Section A1 creates the obligation to make an offer at 340B prices. That's an obligation on drug manufacturers, but of course it's only an obligation for those that voluntarily join this program. And so what happened in that case is really 2 things. The first holding had to do with the federal government's effort to apply an unlimited contract pharmacy requirement. In other words, you had to ship to any contract pharmacy, deliver to any contract pharmacy that a covered healthcare entity identifies. That was beyond the federal government's power. And here's what the court wrote. We cannot plausibly interpret statutory silence, which was the government's rationale, to subject manufacturers to whatever delivery conditions any covered entity might find most convenient. In other words, Congress did not intend to saddle drug manufacturers with an obligation to sell.
It is ironic, but in other words, HHS can't do what the states now seem to be doing.
Well, I think, Your Honor, the states can't do that.
Okay.
And here's I think, the point of this first holding. In this instance, this was Judge Katz's writing from the DC Circuit. He surveyed the statute. He went through the regulatory history. He went through surrounding portions of the act in which the statute was written. And he said Congress did not intend this to be part of the program, this contract pharmacy element. If Congress did not intend that to be a part of the program, they did not leave through silence an opening for the state to act. That's the first holding. That's the relevance in this case. Of that.
But states regulate pharmacies all the time. So your broad position isn't that 340B drugs are just immune from regulation, is it?
340B drugs are regulated by the federal government. Let me just be very clear.
But let's say a state says, I want all drugs to be in refrigerated cars. That doesn't conflict.
That's a law of general applicability. All right, let me just...
So it turns on the fact that this law only targets 340B drugs.
And to be absolutely clear, a 340B drug is one with a federally reduced price, identical in every other way to a non-340B drug. So what has happened here is that the federal government has created a system to lure drug manufacturers into providing these federal subsidies.
Well,
you can be reimbursed.
You opt in and do fine.
We opt in, that's absolutely right, because of the enormous size of Medicare and Medicaid, and it makes sense. But now the program has completely changed, and it's become monstrously larger, and you can see that from the record.
So just because your time's precious, am I understanding, you're making a conflict preemption argument primarily that it's actually imperiling the existence of the whole program. But can you get down the weeds and say it's also conflict because it would be impossible for us to do both?
Well,
or do you want to stay at the Astra level of this is imperiling a program?
I want to do both.
Okay.
And if I might.
Yeah, go ahead.
Let me go to the second and really critical holding that has been ignored by, for example, the Eighth Circuit in the Novartis case. This one is critical because it determines under the federal program which conditions on a federal offer are legal and which are illegal. And let me just explain. The federal offer, as I said, is under A1. If you make a federal offer, you can condition it on bona fide, reasonable conditions consistent with the federal program. If you don't have an obligation to make an offer, you have no obligation to make an offer, then there's no need to sell at a 340B price. So this is a critical issue. And in Section 4 and Section 5 of the Novartis opinion, there were two limitations the court discussed. One was a one-contract pharmacy limitation. That is, you only have an obligation to sell to one contract pharmacy and to the covered entity. That's how this program operated for about half its life. The DC Circuit said that's consistent with the federal program. It's
right.
A bona fide, reasonable condition. There's another.
But that is all still saying HHS don't do this. Congress didn't expect you to force them to distribute their discount drugs at a bigger. Let's just zero in on 358 though. Just tell me, what does 358 require that's in conflict with anything in the 340B?
It makes you sell a drug that you're not at a 340B price, that you're not obligated by federal law to sell. And here's why. All right, Section A1 says you have the ability, or you are obligated to sell at a 340B price. This case that I'm talking about here says, okay, let's see what the extent.
But they're just gonna say, I think, and we're gonna hear them stand up and say it has nothing to do with pricing. Nothing in the text of
And they're wrong.
Okay.
If you look at the definition of 340B price in their statute, which is that's the entire focus of their statute. It's not a law of general applicability. It is tied to the federal definition of what a 340B drugs and A1 that I'm talking about here. A1, the section of the statute. It's about reduced prices, delivery of a reduced price drug, acquisition of a reduced price drug. You can't untangle that from the price. It is intimately related to the price. And here in Section 4 and 5 of the Novartis case, what the court is saying is you don't have an obligation at all to issue these reduced price offers if they don't accept your reasonable federal conditions. One of them, of course, is the one contract pharmacy limitation. In other words, a claims data provision, which was covered in that case, in the Morrissey case, and in our briefs at pages 49 to 51, opening brief.
So you think if you request claims data, you may be infringing 358?
I think that their view is certainly one contract pharmacy. My friend's view is the one contract pharmacy is illegal under state law. It's legal under federal law. It's an important bona fide party offer, illegal under state law. Irreconcilable conflict, Your Honor. Claims data, they haven't been as clear. And I'd like to hear what they have to say about that. But the point of claims data is we need to know what these prescriptions are in order to use our federal remedial opportunities, what the federal statute allows us to do. But here's the key. Say I'm one of the parties in the Novartis case. I say, okay, I know what I need to do in a federal offer. I can use, and pharma members do this all the time, I can use a one contract pharmacy limitation. I can put a claims data precondition there. I don't have an obligation to sell if someone doesn't accept those provisions. But here we are, the state is outlawing them.
Since you said you were covering Astra, I don't know if your colleagues will be.
I am.
Do you want to cover 40 seconds? Because why isn't no private right of action perfectly consistent with still state regulated?
Because what Astra fundamentally did was look at what Congress's intent was. And it was a federal common law issue, right? They were trying to enforce federal common law claims in district, so they weren't using preemption. If it was a state law issue, it would have been preemption, but it was federal common law. And here's what the court said, using exactly the same language you find in the field preemption cases and the conflict preemption cases. The court said, this is according to Congress's intent, it's supposed to be a uniform national program. It's supposed to be a program where centralized enforcement is a key element of ensuring that you're doing something consistent across the entire United States.
Okay, I'm going to, only just because of time, it's only fair, but I think we understand the enforcement problem, and that's how the Western District of Virginia ruled too. So if you have one wrap-up sentence.
I have one wrap-up sentence, and that sentence is that the spending power cases the Supreme Court has decided since Pennhurst are relevant here too, and that's because one of the principal elements of those cases is that Congress cannot impose a condition on the grant of federal monies unless it does so unambiguously. So we're the grantee. We're getting.
I think we got that. Excellent.
All right, thank you.
AstraZeneca. Last name pronounced Kadem? Kadem.
Thank you, Your Honor, and may it please the Court. Act 358 is preempted, first, because it targets participation in a federal benefits program to impose new and costly obligations under state law. And second, because those obligations take the form of a price control, something even Louisiana acknowledges it can't do.
You didn't make a field preemption argument.
That's correct. But we did make a contracts clause argument, which
Yes,
is not involved in the
which you'll get to if you have time.
Sure.
Okay.
So I'd like to start, subject to the Court's direction, with the presumption against preemption, because I think your questions go directly to the heart of the matter. What makes this different from a general law that says you have to refrigerate all drugs? And what Buckman, the Supreme Court, said is, if the state is attempting to regulate something where the relationship is created by federal law, is regulated by federal law, and will terminate according to federal law, that totally changes the equation, and that's what we have here.
But the response is, this state law is only aimed at a totally separate contractual relationship between the hospital and its pharmacies.
So respectfully, the reason that manufacturers are the plaintiffs here is because that's not true. It imposes obligations on manufacturers. We are the ones who are potentially in violation of this law because of our policies.
Counsel, is your claim that you're being forced to sell discounted prescription drugs outside of the covered entities, the contractual relationship with the covered entities? In other words, you're selling more to pharmacies than you should be
So the answer
at a discounted price.
So I would put it slightly differently. The problem is that we are being required to sell at a very steep discount. We're talking about hundreds of dollars worth of drugs selling for $1 or sometimes less. That we're being required to sell them under circumstances where the federal program would not require us to sell them and where we would not choose to sell them if it were up to us.
But we know that the pharmacy has to have a contractual relationship with a covered entity. Let's say a hospital in rural Louisiana, a medical clinic, that entity has to have a contract with pharmacy. And the brief seemed to say undisputedly that they may have contracts with several pharmacies, which is sort of the beginning of what we're seeing here. Still, we're able to quantify that because let's say a hospital in a rural parish in Louisiana serves 850 patients, and only 850 patients. There's some limit, is there not, on the amount of pharmaceutical products that you can sell pursuant to the 340B program. Isn't that correct?
So that's correct. I think there are a couple of points underlying your question. First of all, just as a matter of access by patients or even by pharmacies, that is not an issue. Every pharmacy in the state, and therefore every patient in the state, can get AstraZeneca's drugs. The question is one of price. Can they get it at the 340B price? To your point, it is theoretically possible that every patient of a covered entity might go to an in-house pharmacy and therefore acquire the drugs even under our policy. We just know that's not going to happen. And we know that in part because that's the reason the law was passed. What the other side says, and this is page 15 of Intervener's brief, is that our policies, because of the way they operate, were depriving covered entities of revenue and savings. And the state, at page 35, says that the law is designed to increase revenue.
Is the windfall is for the covered entity? Is that how I understand the federal law to operate? That the covered entity can charge the patient whatever, subject to whatever copayment or anything like that, but the covered entity gets the windfall of purchasing your client's products at a steep discount, and you don't get compensated. Maybe you do get compensated on the back end from the government. Is that? I'm trying to figure out how this all.
That's exactly right. So you take drugs that retail, say, for hundreds of dollars. The covered entity acquires those drugs or has them shipped to a contract pharmacy for, let's say, $1, then charges the patient full price. So the patient pays his copay, the insurer covers the rest, and the difference between them is arbitrage revenue that the covered entity either pockets or distributes with their contract pharmacy partners. But here's the key point. Every dollar of revenue for the covered entity and their contract pharmacy policy partners is $1 out of the pocket of a manufacturer, making it that much more expensive for them to participate in the federal 340B program.
But I guess on the same line of inquiry, in an ideal world, you could still limit it only to the patients that are the rural patients. And so the difficulty for your clients, I understand, the radical enlargement is diversion or double discount.
No, Your Honor.
No.
So
because if it were that, you should just energize HHS and do the audits.
So though they are problems, to be sure, but even if there were no problems, contrary to fact, it would still be money out of our pockets for having to be subject to this law. And it is a state imposing additional financial obligations on manufacturers if, but only if, they participate in a federal program. That is not something that a state is allowed to do. It exerts what the Supreme Court has described as an extraneous pull on the federal program. And consider the fact that Louisiana is not the only southern state that has this law. We're now up to 21 states from Maine to Hawaii.
But what if they say all these delivery restriction laws we're passing is to make sure every deserving patient gets it, no matter how spread they are across the state? So all we want to do is impose a shipment rule.
Yeah. So again, the reason a shipment rule would do nothing is, number one, nothing about this law says anything about patients. Point of fact, covered entities don't have to under this law and usually don't pass along discounts to patients. Second of all, again, AstraZeneca's drugs, like all of the manufacturers' drugs, are shipped everywhere. This has nothing to do with postage or delivery addresses. It has to do with when they can access the discount. And let me give you a specific example. Toro Infirmary is a 340B covered entity here in New Orleans. It has both an in-house pharmacy as well as a Walgreens contract pharmacy in the same building on Fraser Street. Under AstraZeneca's policy, both of them can get access to AstraZeneca drugs, but it is only at the in-house pharmacy that they can access it at the 340B price.
What about the Walgreens on Magazine Street 4 blocks up? That's fine.
So they can also access our drugs, but again, if they
no discount.
Not at the discount. That is the difference. And that's how you know this is a pricing statute. But even if somehow you could characterize this as a delivery statute, it is still a statute that generates millions of dollars in revenue for covered entities and their contract pharmacy policy partners that comes from manufacturers, which means that participation in the federal program is that much more expensive.
So what besides the enlargement, and I understand that, and that's significant, that's thwarting as opposed to supporting,
right.
That's the pull, as opposed to Xyla Life, perhaps. Right. Is there an impossibility aspect to your argument?
Yes, so we don't make an impossibility argument. But the thing is, when you have a federal benefits program where Congress is balancing carrots and sticks, they say we're going to entice you with this, but you have to assume this obligation. Congress made a deliberate choice, and this goes to your question about the Sanofi decision. On pages 704 and 705, what the Third Circuit said is, Congress made a deliberate choice not to impose the obligation on manufacturers to make discounts for contract pharmacy sales available. And now you have a state like Louisiana that says, actually, we don't like the balance that the federal government struck. We're going to push the balance in a slightly different direction. And you have 20 other states doing it as well. And the thing is, at some point, the whole thing is going to topple over, and the federal program is going to be skewed by all of these different state incentives.
Could you give us 30 seconds on the contract claim?
Sure.
Unless somebody else is going to reach that.
No,
as far as you know,
has
no.
the claim.
Okay.
So in Boyle versus United Technologies, the same principles about preemption apply to a situation in which you have a contract with the United States. And in United Healthcare and Allied Structural Steel, what the Supreme Court and this court have said is, if you sign a contract with the government that if you sign a contract that imposes a limited range of obligations that cannot be retroactively changed and impaired unless...
So it's an impairment of the opt-in agreement you have with
That's
HHS.
right.
That's perfect. Thank you, counsel.
Thank you.
I think the last principal argument, Mr. Owen? Yes.
Thank you, Your Honor. Good afternoon, may it please the court. Court. Matthew Owen on behalf of AbbVie. In my time this afternoon, I'd like to cover 3 points. The first is a specific conflict that Act 358 raises with the federal ADR resolution program. The second is our takings claim, and the third is to address some of the court's questions about the volume of sales required by Act 358. So touching briefly on the ADR rule, I think this is important because it gets down into the details of the statute rather than at 50,000 feet. The federal 340B statute, which is 42 U.S.C. 256B, section D3, says that claims about whether a manufacturer has overcharged a covered entity are supposed to go to the ADR procedure. In Astra versus City of Santa Clara, the Supreme Court said repeatedly, and particularly on page 122 of the Supreme Court's opinion, that the ADR procedure is the proper remedy for overcharge claims, but it also said that ADR, the jurisdiction and competence of the ADR tribunal needed to be exclusive so that the agency could hold the control rein of the program and, importantly, administer both 340B and Medicare and Medicaid together, with which it is interdependent. It is undisputed in this case because the Attorney General, in his answer to the complaint, admitted it 14 separate times, but to give you a couple of record citations, 172, 173, 181, that the purpose of Act 358 is to provide a state court remedy for overcharges. And the language of the rule, that is of the ADR rule, which you can find in the record at page 1210, says that an overcharge claim that the ADR tribunal is supposed to adjudicate includes a claim that a manufacturer has limited a covered entity's access to 340B pricing. That is all that this statute does. That is, Act 358 sets up a system of adjudication in state court about whether a manufacturer has limited a covered entity and its pharmacy's ability to access 340B pricing.
So give me a concrete example of how you could be charged with an unfair trade practice under 358 that would interfere with your obligations or your remedial options in the 340B program.
Sure, and the example is actually everything because the ADR rule is so expansive. And again, this is the language of the rule that says that anything any claim that a manufacturer has limited a covered entity's ability to access 340B pricing is an overcharge. Our policy, which says if you don't agree to a one contract pharmacy or one delivery location rule, we won't sell you the drugs at the 340B price at all. That is how this program operated from 1996 until 2010 with no congressional intervention on either end. So that's why, as my friend Mr. Perry said, the DC Circuit held that that condition is reasonable. It's commercially reasonable. It's how most delivery of goods contracts work. But because we have that rule, AbbVie does, that we will offer covered entities drugs, but if you say, as a covered entity, that you want us to deliver them to more than one place outside the confines of our policy, we won't sell them to you at all, no sale. And we're not required to sell them because all that we have to do to participate in Medicare and Medicaid is make a commercially reasonable, bona fide offer to sell drugs to the covered entity at that price.
Counsel, let me see if I can, maybe I know your time is limited, but let's get to the takings clause. I'm trying to see how your ox gets gored by this law. You're manufacturing a product that the state is requiring you to now provide at a discounted price for distribution and sale to patients that are not part of covered entities? Is so you would have sold that product at the regular price, right? Because these are patients that don't go to covered entities. There's a triangle here between your client, the covered entity, and the patient. I should say, maybe it's a square. Maybe there's the pharmacy and the patient. But at any rate, how do I understand what your client is being penalized for, and what is it that you want with a ruling from this court?
Sure. I have two points, a prefatory point and then a direct answer to your question, if that's all right. As a prefatory point, I think it's very important in analyzing these cases to understand that nothing in the Louisiana law, in our policy, or in the federal law is about patients. That is, the Louisiana law, Act 358, what we're attacking is its text, and not rather its generalized purposes. What it says, and this is in the law itself, is that we may not deny, prohibit, or otherwise interfere with the quote, acquisition, not just delivery, the acquisition of a 340B drug by, among other things, a pharmacy, which means we are required to allow someone to acquire our own property at what Act 358 defines as a confiscatory price, one indexed to federal law, but that's what the statute does. The statute says if you want to say, I will not sell my drugs to you, either to a covered entity that's going to deliver them to a pharmacy or a pharmacy directly, AbbVie's position is if you want to ask us to sell you that drug at a confiscatory price, our answer is no, we won't do that, because you won't agree to the commercial terms in our policy. Now, Act 358 turns around and says you cannot deny, prohibit, or interfere with the acquisition of your own property at that price by a third party. Now, that is taking, and notice that when the state wants to defend itself against the preemption claims that the appellants have brought here, what they say is, no, we're not tinkering with the conditions of the federal program. We're imposing our own state police power obligation that's unconnected from that program. But then, when they turn around to defend themselves against the takings claim, they say, oh, no, you don't have any takings claim because this, what we're asking you to do, is a condition of your voluntary participation in what?
Well, voluntariness is part of their argument, but they're also questioning whether you have a property interest at all, because that ended at the point of sale to the covered entity.
This, I think, is very important to understand, Your Honor, is under the 340B program, as Mr. Perry and Mr. Kedem said, our obligation, if we want to stay in Medicare and Medicaid, is to offer the drugs for sale. But we don't have to sell them if reasonable bona fide conditions are not agreed to. In other words, AbbVie manufactures drugs. When we manufacture them, they're our property, they're our chattel, we own them. Then we say, if you're a covered entity in Louisiana, we will sell them to you if you agree. If we'll sell them to you at commercial prices everywhere. It is completely clear in the record that patients pay full price everywhere. They get their drugs everywhere. But if you will agree to one contract pharmacy delivery, as it happened in the 90s, then we will sell you the drugs at the 340B price. Federal law says that's fine. If you make that offer, you can stay in Medicare and Medicaid. If they don't want to accept the offer, that's their business. But if they do want to accept the offer at that price, then great, we'll do that. But what Louisiana comes along and says is, no, you actually have to sell more drugs than that. You have to be willing to sell drugs at a 340B price to covered entities and contract pharmacies, because that's what it says, acquired by pharmacy, even when you won't sell them and you don't have to sell them under federal law, because a covered entity that doesn't agree to a one contract pharmacy limitation doesn't have a right to purchase them and has no right to force us to do so, and neither does HRSA. That's what the Novartis case and even the Sanofi case say. So in other words, in order to get out of the preemption claim, the state says, oh, we're not tinkering with the conditions of a federal program, and then to get out of the takings claim, they say, oh, no, you voluntarily participated in a federal program, and this is a condition. They cannot have it both ways.
We'll hear from them. Are you pressing your argument that there's error in the intervention of the intervener?
We don't need to press that argument on appeal. I think our point is only they have no private rights under the federal law. They have no private rights under the state law. The Attorney General is here to defend it, but it's really a matter for this court. We're not here to press those claims.
Because it's an unusual posture, two consolidated cases. They aren't being opposed. The state isn't opposing it. So I was just wondering whether you were arguing that there's de novo error in the district court having allowed the intervention.
I think we are happy for the sake of efficiency to let that go.
Thank you, Counsel. Mr. Faircloth.
Your Honor, just a moment of housekeeping. I'll be going for 16 minutes.
Okay.
Just a preemption claim. My colleague, Ms. Hunneman, is going to follow behind us for the next 3 claims at issue. And then Mr. Connelly is going to stand up for 10 minutes on behalf of the intervener.
So you've given Caitlin the heavy load, 3. I'm teasing. Go ahead.
May it please the court. Your Honor, what you just heard was a full-throated invitation to create a circuit split with the 8th Circuit. McLean held in no uncertain terms, we conclude that in enacting Section 340B, Congress did not intend to preempt the field. It went on to say, there is no obstacle for pharmacy manufacturers to comply with both Act 1100-03 and Section 340B. So
I think what I heard is more we're creating a conflict with Katsas in the DC Circuit and Judge Bibas in the 3rd Circuit.
I think you're exactly right, Your Honor. And
But why would we want to do that if what they've said is the deal is the deal? HHS can't force them to enlarge the program immensely at their huge financial loss. How can states do what we know HHS tried to do and couldn't do? Doesn't that sound like it's imperiling the federal program?
I don't think it is imperiling the federal program. I think what we have here, if you look at Sanofi and you look at Novartis, all it says is that HHS cannot regulate those areas. That's because the statute is silent as it relates to contract pharmacies, as it relates to delivery. Congress doesn't have any intent as it relates to those two things.
But there's a lot of discussion about how this was the bargain that the federal government negotiated to sort of have this program. The bargain was that they would take some losses at a one pharmacy level, but no one contemplated, and HHS cannot usurp more and say, well, actually, we'd just like to have most of America to get this deal.
Sure, I think that's two sides of the silence point. So you'll hear from them that silence means that there is congressional intent to give this power to private actors. We think it's the opposite. It is, Congress doesn't have anything to say on the matter of contract pharmacies or on the matter of delivery. And that's a perfectly fine place for the states to come to avoid, as you mentioned earlier, pharmaceutical sales, health and regulation, making sure that poor people in the state of Louisiana get medicine. It is the quintessential health and safety regulation that is the stuff of states. So it would actually be odd for Congress not to have said, hey, wait, we don't want states to come in and fill the gap on contract pharmacies and delivery, as a matter of fact. But that's not anywhere in the statute. Our point is the Sanofi and the various silence cuts in our favor, not theirs.
Is you're still at the level of field preemption, or are we getting into conflict preemption? And I heard them stress beyond the notion that this is thwarting the entire existence of the program at a very specific level. These companies agreed with the covered entities that there'd be one pharmacy inside that would be able to utilize this. And at this point, they'd be under state threat of prosecution if they restricted it to that.
Yeah, I take your point, Your Honor. I think that's just a wrong understanding of state law. State law doesn't kick in until the sale happens. What we govern is distribution and acquisition of the drug after the sale's already taken place. So, and that's precisely what the district court said below. That's precisely what the Eighth Circuit has said how the Arkansas law operates. That's all we're doing here. The sale has already happened. We're not regulating the sale of the 340B drug. We're regulating the distribution of the back end. Again, Novartis tells us, and Sanofi tells us, Congress didn't have any say in how that was going to happen on the back end. It left it to states. It left it to private actors, and states can fill that void whenever they want to. And that's precisely what Louisiana did here. And if I might, as it relates to the field and conflict preemption, I think there's a lot of overlap because frankly, I think AstraZeneca was smart to leave the field preemption claim behind. It's hard to see how statutory silence can preempt an entire field. And that's especially so when we're talking about spending clause legislation. Because spending clause legislation is entirely optional. You heard AbbVie jump up here and say, we opted in, we decided to enter this program. It's entirely optional, so it's hard to believe that Congress in an optional program that parties can opt in and out of would have completely ousted state power in that area. So I think field preemption is a non-starter. I think my best case for that is actually Judge Willett's opinion in National Press Photographers. I think there's a perfect outline for how you can approach this case. There, it was Texas regulations of drones in national airspace. The argument was, well, that's preempted because the FAA could regulate in that area. And this court
just back on the front end, back end argument you're making. So in response to the statements that he made, if they were to enforce as to the covered entities, their stipulation that it may not go through pharmacies outside of the hospital, if they were to enforce that, you're saying that would not be a violation of 358?
If they make a sale of a 340B drug and then interfere with the distribution in the back end, that is a violation of 358.
Okay, so let's say they want to get claims data to make sure there are no diversions going on, and they make that request. That's not interfering with the acquisition?
No problem at all. I mean, I'm happy here standing today. The Attorney General would never, ever go out of the way for that sort of claim. The fact of the matter is the federal...
But it sounds like it's interfering with acquisition. The more that the drug manufacturers say, we're going to audit every single one of these pharmacies to make sure they're not selling it to people who aren't entitled, that's sort of interfering, hindering the pharmacy's acquisition of these drugs, no?
Yeah, I take your point, Your Honor. We don't read the state statute to operate that way. We are happy for them to go audit and get their claims data, just the exact price way the 340.
But is it up to you to decide broadly or narrowly what interfere means?
Well, I think there's a certain presumption that states get the benefit of the doubt in their own interpretation of state law. I mean, I think the Attorney General saying, who has the power to enforce the act under the Unfair Trade Practices Act in Louisiana, saying, I would never enforce the act that way, is more than enough evidence under Pennhurst to say, yeah, we've got to defer to the state Attorney General on how she believes the question of state law should be interpreted. And that's especially so.
So how would they violate this 315? What's something that the companies really might do that you would then think is an unfair trade practice?
So, again, I think the obvious example is they have made a sale of a 340B drug to a covered entity, and then the covered entity says, I would like you to ship it to the Walgreens over on Magazine Street. And they say no. Then we're in 358 territory.
Right, but that's their point. Well, let's say they've got data that Walgreens on Magazine Street is diverting or double discounting. They have those defenses available to them if they're in 340B land. Would those be recognized in state court?
I think if they have a problem with a Walgreens that's double discounting or a diversion.
That's exactly in response to your hypothetical. They say, no. That pharmacy is one we've identified as violative under federal law. Can they bring in the federal defense into state court that they would easily have access to in front of the dispute resolution?
I think the 340B program says they don't get to unilaterally declare what is diversion or what is a duplicative discount. They lay out in the 340B program how you can go about proving that. It's sort of the good faith negotiation on the front end, the audit on the back end, but they can't unilaterally show up in state court and say, well, we believe there's diversions going on somewhere. That would not be a federal defense. So, Your Honors, if I might, I want to return to the point on national press photographers, because I do think that is the roadmap for this case. There, Judge Willett wrote that the FAA not regulating in the space of drones left more than enough room under both field and conflict preemption for the state to step in and regulate in that area. And that is precisely the case here. We have Novartis, we have Sanofi saying, not only can HHS not only is HHS not regulating this drug, it would be unlawful for them to step in and regulate contract pharmacies or to step in and regulate delivery of these drugs. And so this is more than just a parallel of the case. This is a step further. If you apply national press photographers, I don't see how the conflict preemption claim gets off the ground. HHS cannot regulate that area. That's more than enough evidence for you to say, well, states can. And I think the other best case, frankly, is Judge Engelhardt's case in Burroughs. Burroughs goes on and makes it clear that, look, this is not supposed to be some judicial freewheeling exercise of what's the federal objective and what's not. The North Star has to be looking for that congressional intent. I haven't yet seen the identification of the congressional intent to preempt the states acting in this area. It just is this impairment theory that's nowhere to be found in this court's conflict preemption doctrine. And so if you follow Burroughs, if you follow national press photographers, I can't see how they make out field preemption or a conflict preemption claim. And that's precisely what the McLean, the Eighth Circuit arrived at in McLean. There's just no way applying basic principles of implied preemption that you can state a preemption claim here.
Am I simplifying when you say your view is this is purely a regulation of distribution, it has nothing to do with price?
Yes, Your Honor.
It doesn't implicate the price.
That's exactly right.
Okay, so describe as simply as you can the replenishment model, how CVS and Walgreens charge back at the end of the game. If your position is they're all getting it, and it still doesn't even implicate or touch the price point, what's going on with the replenishment model?
So, Your Honor, if I might, a threshold point on the replenishment model, it's sort of held out as the boogeyman in all the briefing, but I didn't read anything in the statutes that Congress passed that says the replenishment model.
No, but just tell me how CVS and Walgreens were never intended to be the beneficiaries of this program. But according to the briefing, correct me if I'm wrong about that, according to the briefing, at the end of the day, especially if they can guarantee through state law that they all get to sell at full price discounted drugs, they're walking away with a lot of money. Is that wrong or is that right?
Well, I promise to answer your question, but the reason I say that is because The replenishment model is not some sort of congressional intent that we can use the replenishment model as a way to say preempt state law. That's not in the 340B.
But your brief repeatedly says 358 doesn't touch price. So I'm asking you, based on the Schindler Declaration and the records here, you can confidently say 358 has no impact on pricing.
I can't hear right.
You can.
Yes.
Okay, so explain, how do they get reimbursed? Who gets charged full price and who gets the reimbursement?
So again, the sales don't happen, and Judge Engelhardt was getting to this point a little bit earlier. None of these sales happen with a Walgreens or a CVS or a street corner. The sale is with the covered entity. Now, the covered entity then acquires those drugs, and they may want to acquire those drugs and have it at a Walgreens so that somebody in rural Louisiana can go get it from the Walgreens. So the only...
At full price?
They could get it at full price, and if Walgreens, I doubt they would, but for some reason wanted to discount it, then they can't.
I thought that the way it worked, they buy it for full price, and after that, there's a chargeback. Am I wrong?
Yeah, that is right. There is a chargeback, but it's the covered entity that benefits from that chargeback. And that's exactly what the 340B program is intended to do. Admittedly, look, this isn't supposed to be some sort of pass-through scheme where the patient always sees the benefit of that reduced rate. It is supposed to keep the rural hospital in Louisiana open. That's what it's designed to do. And so, yeah, there is going to be some revenue there that goes back to the covered entity. But to be clear, what the pharmacies do here is just a service. The pharmacies are simply dispensing the drug to the patient. It's the covered entities that get the money in the end. Now, whether or not the covered entities pay the pharmacies for that side service that they do, I think it's a downstream question from what the preemption question we have here.
So you're leaving it unclear whether they get any money back. I thought the record's pretty clear they get an enormous amount of that money back, but no?
No, I don't think that's correct, Your Honor. I think the pharmacies are paid for providing the service they provide. Even assuming 340B doesn't exist, pharmacies all the time get paid a service charge based on dispensing a drug for your neighborhood doctor around the street. And so that's just the arrangement of how it works between a pharmacy and a healthcare provider. And all we're saying here with 358 is you can't interfere with that relationship. That relationship is important for Louisiana patients, it's important for Louisiana health, it's important for our rural hospitals. You cannot interfere with it. That's it. That's all 358 does. And we have no Veritas and Sanofi saying HHS can't even act in this area. It would be unlawful for them to do so. Again, applying national press photographers, I think applying Burroughs, you can't make out a preemption claim under those circumstances. Your Honor, if there are no further questions, I'm happy to give back the remainder of my time.
Thank you, Counsel. Ms. Hughes, you'll have to pronounce your last name for me.
Sure. Caitlin Hutterman, on behalf of the Attorney General. As my co-counsel indicated, I'm going to be addressing the three remaining secondary claims raised by each of the appellants here. First, Pharma's due process for vagueness claim, then AstraZeneca's contracts claim, and finally AbbVie's takings claim. Each of these the district court properly rejected under detailed analysis, and we urge this court to affirm. I'd like to start with Pharma's void for vagueness claim because I think it's the easiest to dismiss under this court's controlling precedent. We lay out the long spiel about what it takes to make a statute unconstitutional under the void for vagueness doctrine, but I just want to point out a few key tenets of this standard. First, to be unconstitutionally vague, a statute must be impermissibly vague in all of its applications, including its application to the party bringing the claim. And for every application, a plaintiff must show that the law is so unclear that people of ordinary common intelligence must necessarily guess at its meaning and differ as to its application. If that sounds like a daunting burden, it's because it is, as this court has said before, and it's especially daunting in the civil as opposed to the criminal context. This is the civil context here, and so there's only a vagueness issue where there is no standard of conduct actually outlined or defined in the statute. And that's not what we have here. Pharma is feigning confusion with the word interfere in subpart A and subpart B. But as the district court properly analyzed using various statutory canons of construction from the associated words canon, looking at dictionary definitions, the word interfere can be easily and permissibly read in statutory context to not be unconstitutional. What Pharma raises are a few speculative applications of the word interfere.
But the whole 340B system turns on them being able to get the data that allows them to audit a pharmacy. So do you accept your co-counsel's statement that, well, interfering wouldn't apply to interfering with collecting that data? And if so, how is it that the Attorney General can just say a natural reading, hindering, interfering, impairing, isn't actually what's behind the word?
I think that falls from other state law, Your Honor. Louisiana Revised Statute 40:2886B1 explicitly says that nothing in Act 358 is to be read in conflict with other federal law and regulations. So to the extent pharma says, oh, well, the word interfere means that we can't conduct our audits under 340B, state law says that there is no problem there with the word interfere because we can't use interfere to interfere with your obligations under, or your rights under 340B. So that wouldn't even be an application of the word interfere, let alone a vague one.
But if they take that assertion literally, then they'll just be making in any unfair trade practice argument exactly that argument. We've got a federal law that guarantees that we only need to give to the covered entity, and therefore we can enforce our stipulation that only one pharmacy gets it, because you've said we'll comply with the federal law described by the Third Circuit, the DC Circuit.
I disagree with that interpretation, Your Honor. What 40:2886B1 says is that Act 358, in the sense that it prohibits a manufacturer from, interfering, hindering, preventing that delivery to the contract pharmacy, that in understanding Act 358, in interpreting that state law, you can't read it to then interfere with federal law. Now, as my co-counsel argued at length, federal 340B has absolutely nothing to say about that delivery. So if we're talking about interference with delivery, we're purely in the realm of Act 358 and state law. We're not in 340B territory. I'll turn now to AstraZeneca's contracts clause claim. This is an argument that defies the reality of heavily regulated industries like this one. AstraZeneca wants its contract to be untouched by state law in every way, shape, or form. That's not how these industries work, and it's certainly not how the contracts clause works. Of course, the contracts clause says that no state may pass a law impairing the obligation of contracts. But the Supreme Court, this court, no court has ever interpreted it so broadly to say that a state law can never affect or impair a contract. There must be a substantial impairment, and only if there is a substantial impairment do we then look to the state's purpose and whether that purpose is reasonably tailored to the statute. Here we don't get past the substantial impairment step, and I think there's at least 3 reasons why that's so. First, Act 358 concerns an altogether different set of contracts than what AstraZeneca is proposing. They want you to focus on their PPA, their pharmaceutical pricing agreement with the Secretary of HHS, and say that Act 358 substantially impairs that contract. But Act 358 has nothing to do with that contract. Act 358 affects the contract between the covered entity and their contract pharmacy. It's more of a lateral contract, if you want to create a visual here. The PPA goes up and down between the manufacturer and the covered entity. The Act 358 steps in at this lateral level between the covered entity and the contract pharmacy. Far from impairing contractual rights, Act 358 actually prevents impairment of this private contract right. And so for this court to then say, well, we're going to nullify Act 358 and we're going to prevent impairment of contracts that Act 358 intends, sort of creating this winners and losers situation that the contracts clause was not designed to create.
What about the contract between the pharmaceutical company, plaintiffs in this case, and the pharmacies? They sell certain pharmaceutical products, prescription drugs under 340B, but then they presumably also sell full price or regular price to the same pharmacy. Is that contract right involved at all?
It doesn't seem like it from AstraZeneca's argument. They're focusing entirely on that PPA, that statutorily defined contract that they enter into with the Secretary of HHS. And they say that Act 358 substantially impairs that by expanding the list of covered entities that they have to offer their drug to. And our position is that no, Act 358 doesn't step in until, as my co-counsel said, you've already made that sale. 340B is done, and now we're at the second level, again, that lateral contract. To the extent Act 358 does affect the 340B-based PPA at all, the rights and obligations in those agreements are largely unchanged by Act 358. That's because AstraZeneca agrees and continues to agree on a yearly renewable basis in that PPA to offer 340B drugs to covered entities at a set or below that set price, and AstraZeneca's contractual right in return, the large benefits it receives in the form of access to Medicaid and Medicare reimbursements, is likewise unchanged. That's not impairment, let alone substantial impairment. And to the extent Act 358 does expand some contractual rights, that's not a contracts clause problem. Quite literally, every state, every law and regulation in those 50 states imposes additional obligations on private actors. And that's especially so, again, in these heavily regulated fields like the pharmaceutical industry. Whether those regulations have nothing to do with private contractual rights, slightly affect those contractual rights, or substantially impair them, that's where the contracts clause steps in. And AstraZeneca's suggestion that its bargain would be different and so there is a contracts clause problem is simply wrong. The form agreements imposed by HHS have no negotiable terms, and even if they were negotiable, the terms align with HHS's previous history of regulation. Going back to 1996, just 4 years into this program, contract pharmacies were a part of the equation. Now their use increased, but from 2010 to 2020, a covered entity could send its drugs to any number of contract pharmacies. And again, the manufacturers took no issue with that up until 2020. The last point I'll make here is that their reliance on allied structural steel is misplaced. That case is easily distinguishable from this one. The Supreme Court there held that the Minnesota law at issue expressly nullified the terms of the parties' contracts. No argument has been made to that effect here. And the court went on to find that the Minnesota law imposed completely unexpected liability. And again, if you look at the history of regulation here, the use of contract pharmacies was not unexpected. Even if Your Honors find substantial impairment, the legislature clearly had a suitable purpose in passing Act 358 I would point Your Honors' attentions to the U.S. Supreme Court decision in Exxon Corp v. Egerton, where they found that protecting consumers from excessive prices alone was sufficient under the contracts clause. And Act 358 serves that purpose by attempting to ensure that Louisiana residents can access their drugs across the state. Because I have such a brief amount of time left, I'm going to jump back to the takings clause raised by AbbVie here. There are two bases to affirm the district court here. First, that there was no taking, as the district court found, whether that's a per se physical taking or a regulatory taking. And second, that even if Your Honors do find that there was a taking, because Act 358 serves a public use, the only remedy available to AbbVie is just compensation, not the injunctive and declaratory relief that they seek.
So your response to the takings claim is not reliant on the fact that they're voluntary participants?
That's part of the equation, as you mentioned, Judge Higgins. It's not the whole ballgame, but it doesn't matter. And I'd actually like to point your attention to the Rule 28J letter filed by the intervener defendant just last Friday. It points to a Ninth Circuit decision from just last week that held that in the pharmaceutical industry, not just the 340B program specifically, but the industry as a whole is so heavily regulated that parties have to reasonably temper, it's necessarily tempered, their expectations participating in the field. That not only might their property be diminished in value, but their property might be rendered entirely useless when they're participating in these fields. But that's okay because they receive such valuable government.
But states can't utilize voluntary participation in a federal program to justify any taking and say, well, you've participated in the federal program, so we can take whatever we want.
Your Honor, I think that distinction is it's a bit of a straw man, but even if that were so, and if Your Honor thinks that...
Well, I thought your argument was that we should look at the fact that they've opted in. It's a voluntary participation.
That's true, and it's not just the 340B participation that the Ninth Circuit and all these other courts that have rejected identical takings claims are focusing on. It's participation in the pharmaceutical industry as a whole.
Okay.
And the fact that it's such a heavily regulated...
State and federal governments regulate.
It's a combination of the two.
Thank you, counsel.
Thank you.
Appreciate it. We have intervener argument, Mr. Connelly.
May it please the court, my name is Ronald Connelly, and I'm counsel for the Interveners Louisiana Primary Care Association. I'd like to talk about some issues that run through all of these claims. Preemption, takings, contracts clause. The three things I want to touch upon, if I may, are whether patients get the benefit of this, the pricing distribution, distinction, and replenishment. I'm going to try not to replow any ground that's already been covered. First, I want to be very clear that the 340B program is not a patient discount program, it's a provider discount program. Patients do benefit from it, but the purpose of the program is to provide discounts to safety net healthcare providers that serve rural populations and inner city populations. These are patient populations that are often uninsured, underinsured. And the purpose of the program is, as Congress said in the House report accompanying 340B, is to stretch, enable these covered entities to stretch scarce federal resources, enabling them to reach more patients and providing more services. So the 340B program does benefit patients basically by keeping these providers afloat in a very challenging economic environment. The Genesis Court in South Carolina got it absolutely right when it said, put simply, the purpose of 340B is to provide a means to make 340B entities profitable in order for those 340B entities to stretch these scarce federal resources. So that's how patients benefit indirectly by keeping their healthcare providers afloat. And of course, many covered entities do pass these discounts on to indigent patients. Many Louisiana Primary Care Association's members do that. So that's sort of how the 340B program operates. You've heard discussion on the pricing distribution distinction. The manufacturers will tell you that Act 358 is a pricing statute because pharmacies in Louisiana can already get all the drugs that they want, and Act 358 is just controlling the price at which they get the drugs. This argument conflates two issues, two different types of transactions, and this is also the same analytical error in the Morrissey case in the West Virginia District Court. They're conflating transactions between pharmacies and manufacturers and covered entities and manufacturers. They're totally different. It's true that pharmacies can buy all the drugs they want. Those are transactions that aren't covered by 340B and they aren't covered by Act 358. Pharmacies can buy all the drugs they want, get them shipped to the pharmacy and dispense them to patients. What is at issue in these cases are the transactions by covered entities. And Mr. Faircloth was exactly correct when he said that Act 358 kicks in after the sale has already occurred. So there's a sale from a manufacturer or a wholesaler to a covered entity at the 340B price. And then once that sale has occurred, Act 358 kicks in and says, manufacturer, you can't block the distribution of that drug to the pharmacy. So we're not talking about transactions between pharmacies and manufacturers. We're talking about transactions between covered entities and manufacturers, and then
so just chronologically, it's only once they've already acquired the drug and it's the transaction and the shipment from the covered entity to the pharmacy.
That's right. So, yeah,
but am I just missing something? What if before, in the period you say 358 doesn't affect it, what if the drug company says, we're not going to ship it to you, covered entity, unless you tell us you aren't shipping it to more than one? You're saying 358 does not say that that's an interference?
Well, to be clear, these shipments generally don't go to the covered entity.
I know, but they say to them, we're not going to send it to where you want us to send it. This is still in the first chronology. We haven't yet relinquished authority. So the representative, the intervener in front of you, Fifth Circuit, has said 358 has no bearing on this moment. The drug company says, we will not ship it to that address. We will only ship it to the hospital. You're saying 358 would not make that an unfair trade practice?
358 would make that an unfair trade practice.
But you just said to me, chronologically, we're talking about two different time periods. And 358 does not affect the period, the relationship between the covered entity and the drug company. But now you're saying, yes, it does.
358 affects the policy limiting distribution to the pharmacy. So the way the 340B program works is that there's a price file that's given to HRSA by the manufacturer setting the 340B price. And then covered entities are then able to purchase those drugs at that price. It's not, you and I can't look that up, but the covered entities can access that pricing that HRSA has. And then they purchase those drugs. And then after the sale, the manufacturers are saying, well no, we're not going to allow shipment of those drugs that you've purchased to the pharmacy where they can be distributed, where they can be dispensed to patients in the covered entity. that answer your question?
I guess it does, and it's in the record, and I've just always been a little bit confused in the replenishment, but I'm think I'm just oversimplifying whether or not 358 interferes with the relationship between the drug company and the covered entity, and I thought the answer was no, it doesn't. It only regulates the relationship between the covered entity and the pharmacy. But now, in fact, what I'm hearing is, no, it would be interfering with that separate relationship if the communication from the defendant to their covered entity is, we're just shipping it to you, and we'll stop shipping unless you sell it in your hospital.
I think we might be
Yeah.
saying the same thing a little bit differently,
Okay.
frankly.
Well, you've got, I mean, I'll clear this up in the record. You keep going with your points.
They're actually, since these policies have gone into place, there are some covered entities that have directed shipment to the covered entity, and then they load them in trucks and send them to the pharmacy.
Right.
Their policies generally don't prohibit that because the initial shipment is to the covered entity. So, you know, so an Act 358 does not increase the number of eligible transactions. Because a covered entity, let's say a covered entity has 1,000 patients that need 1,000 units of a particular drug. That's the eligible body of 340B transactions.
Right.
If they have all those drugs shipped to the covered entity, the manufacturer is going to ship them, 1,000 drugs are going to go to the patients, the discounts are going to go to the covered entity. There's no dispute about that. If they direct shipment of any of those to the pharmacy, then they block those. So it's a distribution. Act 358 is a distribution law because it's requiring the manufacturers to honor that distribution contract between the covered entity and the pharmacy. It doesn't increase the volume of.
I guess I'll have two observations. Maybe one's a question. I would think you, as an intervener, are pretty dependent on them. In other words, that's a powerful, important partnership for them to continue to participate in the discount program.
The manufacturer?
Yes. It's not an antagonistic relationship. It's one of, maybe you don't have to answer that. It's just a naive observation. But go ahead.
I would just say that, yes, certainly the 340B program is very important to covered entities. As I mentioned, it's what helps keep them afloat. The problem here is that if the drugs can't reach the covered entity patients, then
that's a huge problem.
Covered entities can't get the discount.
But your world, what you're communicating to me sounds like there is a restricted group of people who are entitled to these drugs at a discount, critical patients of yours. Is the big problem that's generating most of this litigation that they see CVS and Walgreens beginning to sell it to willy-nilly? And if that's the big problem, is that an enforcement issue for HHS?
It is. So now you're referring to the replenishment model. I've got less than a minute. So
no, go ahead. This is helpful. Thank you.
You know, in the replenishment model, the pharmacy, when a patient walks into the door, the pharmacy may not know whether or not that is a patient of the covered entity. They dispense the drug that they've already purchased. And then afterwards, they figure out that, oh, this was a patient of a covered entity, should have been at the 340B price. So then the covered entity orders a replenishment drug that basically pays back the pharmacy. It doesn't increase the number of transactions, and importantly, this is a federally blessed model. And in a sense, it really has nothing to do with Act 358. If they think that replenishment is resulting in diversion or duplicate discounts, they should go to HHS, they should go to HRSA and say,
Mr. Connelly, quick, 4 seconds, 3.
No, as much.
Just so I'm clear, what different defenses are you providing for Act 358 that Louisiana doesn't itself tee up?
I view my role here before you today is just to expand upon some of these issues that Mr. Faircloth and Ms. Hoodman very capably discussed.
Okay.
Thank you.
Let's see. So it's 2, 4, and 4. Okay.
We're allowed 2 minutes, Your Honor. Let me just start with something my friend Mr. Connelly said, and returning to sections 4 and 5 in the Novartis case. If a covered entity, contract pharmacy, does not accept the one contract pharmacy condition or the claims data condition, there is no sale. You don't sell it and then see where you deliver it later. There is no sale at a 340B price. They can buy the product at a commercial price, but he's mistaken. There is no sale at the 340B price. Now, I think Mr. Faircloth characterized Novartis and Sanofi as meaning that the federal government has nothing at all to do with delivery at all of 340B price drugs. Both those cases were about the effort to mandate unlimited delivery, not whether the federal government had any authority about delivery. And in Novartis Section 4 and 5, they explain exactly what the federal government's obligations are, how it deals with delivery, how it regulates delivery. And in fact, on page 30 of our brief, we quote the federal government explaining that it can regulate delivery and does through the ADR process and through sections D 1 through 3 of its statute. These two statutes, in their enforcement provisions, overlap. They cover the same territory. Conflict is imminent, according to the Supreme Court, in those circumstances. The McLean case that my friends referred to was decided before Novartis clarified this. It didn't have the benefit of having Novartis decided, where Novartis explains exactly the bona fide condition doctrine for conditions on 340.
Mr. Perry, circling back quickly to field preemption, has this court ever found federal field preemption in the face of statutory silence?
Sure, there's ERISA cases, but I think they have there are a number of preemption cases we cite where field preemption, but as you noted, I've been working on primarily conflict preemption theories today.
Right.
I think Astra would justify field preemption given its description of congressional intent. You might say, what is the appropriate field? And I would suggest to you that it's eligibility for 340B discounts. The field is, what do you need to offer? That's precisely what Novartis dealt with. It's diversion. It's all of the components that make this program work at the federal level. And that includes restrictions on delivery that are bona fide and reasonable. That's within the federal field.
Okay, thank you, counsel.
Thank you, Your Honor. Starting briefly where my friend Mr. Perry did. We heard the state say that this act just doesn't kick in until the sale has already occurred. And if only that were true, we could probably shake hands and go our separate ways. Unfortunately, however, the statute doesn't just talk about delivery, it also talks about interfering with acquisition. And it has to say that because that is what all of the manufacturer policies do. AstraZeneca policy says, if you aren't willing, if you are trying to place a sale for a non-designated contract pharmacy at 340B prices, you simply cannot place the order in the first place. It's not that you can place the order but can't get it distributed. Now, you asked my friend, Mr. Connelly, point blank, would that violate the act? And he had to say yes. And the reason he had to say yes is otherwise this act would have no effect on the very thing it was designed to do, which was to make these manufacturer policies unlawful in the first place. But insofar as the court has any questions about whether that's the case and whether our policies actually restrict delivery or just the initial offer in the first place, we would be happy to prove that in discovery. Turning to the question of whether this regulates price or not. Again, put to the side that that's really, in some sense, just a semantic question, because even if it does regulate delivery in some abstract sense, it's still an incredibly costly multi-million-dollar delivery obligation, and that by itself would be enough to tell you that it was preempted, because it's a new costly delivery obligation that was being imposed on a federal program. But in fact, it's not a delivery obligation at all. It has to do with price. And the replenishment model makes this crystal clear because, as we all understand, you don't determine eligibility for a 340B sale under the replenishment model until the patient has already acquired the drugs, walked out the door. At some future point, days, weeks, or even months later, someone combs through the data and says, aha, that was a patient of the covered entity. Let's place a replenishment order at a discount. And then there's a financial reconciliation. You heard my friend from the state talk about a chargeback. Well, to me, chargeback sounds a lot like pricing. You also heard my friend, Mr. Connelly, talk about revenue generation, profit, keep us afloat. Again, those are all terms that have to do with the arbitrage revenue that you get when you buy drugs for a low